We always see people at the closing table with puzzled looks on their faces about a lot of stuff. Let's talk about some of the things, the questions you should ask as a consumer before you get to the closing table. And ask this to your attorney, right?
Yep.
So can I ask you a couple questions?
Sure you can.
So cash to close. Let's talk about that. Let's explain that. So what do you mean by what is the cash to close? What does that mean? What's in the cash to close?
So the cash to close is the end sum of all the closing costs. You're taking the purchase price into consideration. The deposit that you've put down, earnest money deposit when you sign the contract, your mortgage amount, if you're going to have a mortgage or not, and all the closing costs in between. The lender's closing costs, the recording, the title, everything. And when everything is said and done, credits as well. Of course, there's credits for
oil to the. Oh, wait, that would. Yep, would that
that's
be it?
Yeah,
for
sure.
The seller.
Well, that's going to add something. Give a credit to the seller, but a debit to the buyer. But after all that's said and done, the bottom line figure is what is called the cash to close. That typically needs to be given in the form of a cashier's check or a money order. That's an important thing to bring up because you don't want to come in with a personal check or cash. That happens once in a while where people will say, okay, who do I write that check out to? Well, you don't want to pull out your personal check at the table because we need to have cleared funds. We need to have funds that we can rely on. And not to say that you don't have those funds in your account, but, we have to disperse to a seller immediately after the closing.
Sure.
And that's something that we would have to rely on, funds that are, certified.
Let me ask you something else from a liability standpoint. Let's just say somebody closes on a Friday. It doesn't get recorded in town or the city until Monday. Is there a liability there for that seller? And if so, what can they do to limit their liability?
Well, I always, and that issue comes up all the time. That's
at
why
the closing.
You brought that up, right?
Yeah.
And so I always tell both parties, the buyer has their insurance in place, the seller has their insurance. I tell, until we record, even though the deed has been executed, and the execution of the deed is kind of the moment in time where the title transfers to the buyer, but we got to record. That's the whole process is about recording, and the recording of the deed and the mortgage and everything else puts everybody on notice, not just the two parties at the table, but everybody on notice. So it kind of all works together. But I always let the seller know, for liability reasons, don't cancel your insurance policy until we've told you, and we always let the agents know after the documents are recorded that we are on record. And once we're on record, you can go ahead and cancel your insurance or let your mortgage company know that the property's been sold. Don't disperse from an escrow account for taxes and insurance, that kind of thing. But don't cancel that policy before you come to the table.